Now, before we move on to taking a look at each of these segments, it's important to just demystify some of the technical terms that we'll come across in the bill. So these are just basic concepts that need to be clarified to avoid any confusion when we're dealing with the definitions and other provisions of the bill. The first important concept to break down is that of data processing. It's important to understand what this means because it's basically central to the bill. It's the central activity, right? Any kind of data processing, so long as it involves personal data and it falls within the scope and applicability of the bill, will have to comply with the obligations and standards and safeguards under the bill. So data processing, interestingly, is also a concept that we actually came across under the Information Technology Act, but it's not really defined under the IT Act. So this is a significant departure from the Information Technology Act, in that now the new bill lays down a proper definition for this term. So Section 3 of the Personal Data Protection Bill, which contains all the definitions, provides that data processing means an operation or a set of operations that is performed on personal data. And by way of example, that definition clarifies that data processing includes collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, use, alignment, indexing, disclosure, dissemination, erasure and destruction of personal data. Let me just make this much easier to understand. Recording, let's take one of those examples. So as per this definition, recording of personal data is data processing, and that's exactly what's happening right now. What I'm saying and what my actions are being recorded and being transmitted to you. So this act of recording my personal data is technically data processing. So this is a live act of data processing that's going on here. And this definition is significant because it's very, very wide. Pretty much any activity that you carry out with relation to personal data would qualify as data processing. Because think about it, right? How do you deal with your personal data? You use it, you collect it, you store it, you disseminate it, you publish it online, you write it down, you collect it, right? So as long as any of these activities are taking place with respect to personal data, it would qualify as data processing. The next concept that you should be aware of is that of data principles. So data principles, simply put, are people whose personal data is protected under the bill, right? Again, Section 3 of the bill for reference if you want to take a look at the actual definition. Data fiduciaries is the next concept that you should be familiar with. It's something that I've already briefly covered for you, but just to recap, simply put, a data fiduciary is an entity, typically a body corporate, but it can include the state, any juristic entity as well, that controls why personal data is processed and the means by which that personal data will be processed. So they basically call the shots with respect to personal data processing. And data processors are the folks in the assembly line of data processing, so to speak. These are the guys who will process the personal data on behalf of the data fiduciary. So the data fiduciary will decide that, let's say, personal data is going to be processed for, can we cut that? So those are the key concepts that you need to be aware of before you actually start to tackle the key provisions of the bill. So now we can take a look at the territorial scope and applicability of the bill, right? Who the bill applies to, when and where. Now Section 2 of the bill is what you should refer to when we're discussing this. The bill provides that it applies to processing of personal data by data fiduciaries and data processors that operate in India, even if the data processing takes place outside India. Let's break this down and give you a fact situation. Let's say that there's an Indian company that's operating in India, Fatafat Internet. Its job is to survey Indian citizens and collect information about their internet speeds and pain points that they experience when they're trying to access data. It then takes that information, transfers it to its arm in the United Kingdom, where analysts sit, structure and organize that data, and basically come up with solutions to the problems that these users face back in India, send that information back over to the Indian arm, and the Indian arm of Fatafat Internet then reaches out to its Indian users, right? So what's happening here is, in terms of technical terms that we've understood right now under the bill, is that there's collection of data, so that's data processing, that's taking place in India. Then there's transfer of that data, and then there's structuring and organization of that data in the United Kingdom. Now that is also technically data processing. So here's a company that operates in India, but some of its processing is taking place outside India. For the purposes of the bill, that it still applies to this company. So the fact that the data processing is taking place outside Indian borders does not mean that the Personal Data Protection Bill will not apply to that particular aspect of data processing. So whatever those analysts sitting in the UK are doing with the information that they got from the Indian arm of Fatafat Internet will have to comply with the standards that are set out in the Personal Data Protection Bill. That's basically what it means. The bill also applies extraterritorially. That means it applies to anybody who's outside the borders of India, to data fiduciaries and data processors who are outside India if they process personal data that's connected with any business in India and that's connected with any activity which involves profiling of data principles in India. So again, by way of a fact situation, if there's a company located in Abu Dhabi and they're collecting information about the social media, they're collecting information on social media activities of Indian citizens, and they're trying to create a user profile, they're trying to create a customer profile, and try to like sort of chart the consumer behavior of these citizens, then that information gathering and that data processing will fall under the Personal Data Protection Bill, because it's relating to activities that are profiling data principles in India. Right, so that's data okay. Now let's take a look at the kinds of data that are protected under the bill and the key actors in this personal data protection framework built under the bill. So there's personal data, which, as I'm sure you've guessed, is data relating to any natural person who is directly or indirectly identifiable. Then there's sensitive personal data, and this is interesting. So under the Information Technology Act, we took a look at 6 categories of sensitive personal data. And Section 43A of the Information Technology Act only protects sensitive personal data. Under the Personal Data Protection Bill, you have personal data, of course, which is protected. And then there is sensitive personal data, which is different from the kind of sensitive personal data that we looked at under the Information Technology Act. So we had 6 categories under the IT Act, and we have 12 categories under this bill. So sensitive personal data, as it's defined under Section 3 of the bill, is any data that reveals or is related to, number 1, passwords. Number 2, financial data. That was also covered under the IT Act. Number 3, health data, also covered in some form under the IT Act. Official identifiers, this is new. Basically your driver's license, voter ID, Aadhaar card, etc. would be your official identifiers. Data relating to revealing your sex life, sexual orientation, biometric data, this is also similar to the IT Act. Genetic data, this is a new category. Transgender status, also a new category. Intersex status, again new. Caste and tribe data, religious or political beliefs, or any other category of data that's specified by the Data Protection Authority. So all of these categories of data are considered sensitive personal data under the Personal Data Protection Bill. And while personal data is protected under this bill, sensitive personal data is protected under an even higher standard. So that's something to keep in mind, where under the IT Act, the baseline protection was for sensitive personal data. There was nothing for personal data. Under this new system, under this draft bill, you have a baseline standard of protection for personal data and a higher standard of protection for these 12 categories of sensitive personal data. I say 12 categories right now, but this list is subject to change given, that the Data Protection Authority is given the power to add more categories of data under this list. The Data Protection Authority, in case you're wondering, is basically the regulator under the bill. So, critical personal data. So, the central government is empowered to notify an additional category of personal data that's classified as critical personal data. And what's special about this data is that it can only be processed in servers or data centers that are located in India. Okay, and so it's undefined as of yet. We have to wait for the central government to actually notify what categories of data would be considered critical personal data. But at this stage, suffice it to say that anything that's critical personal data has to be stored in India, in a data center in India. It cannot be transferred outside India. It cannot be stored outside India. No sort of processing for this data can take place outside India. So those are the three main categories of personal data under the bill: personal data, sensitive personal data, and critical personal data. And then there's anonymized data. Now, anonymized data has been defined to mean any data that has been irreversibly converted to a form where it cannot be used to identify anybody. So it's basically harmless data, simply put. If this data were to come in the hands of a third party, that third party would not be able to relate that data to a data principle, right? So if your voter ID or if your daily behavior on Instagram were to be completely anonymized, which is to say that it's completely delinked from you, your user profile, your pictures and all of that, it would technically be anonymized data as per the definition that's currently given under the bill. And this data, if it were to come into the hands of a third party, would be harmless because that third party would not be able to relate that anonymized data to you as a user. So anonymized data, so long as it meets this standard under the bill, is not protected by the Personal Data Protection Bill. And this stands to reason because if it cannot be linked to a data principle, it technically doesn't need to be protected. But it's not as simple as that because anonymization can be a complex process. It's a dynamic process because it changes as technology changes. So it's important for the bill to have perhaps more clarity on what anonymization means, and it remains to be seen how the subject is tackled under the bill. But for now, what you should know is that any data that's anonymized data for the purposes of the bill is excluded from the scope of the bill and it's not protected by it. Key actors under the bill is something that you already know, but we'll just quickly go through it to refresh your memory. There's data principals, you and I, everyday citizens whose data is protected under the bill. Data fiduciaries, companies, body corporates, even the state, government agencies, any juristic entity that decides how personal data is to be processed and why it's to be processed, the purpose and means of processing personal data, and data processors who actually do the processing on behalf of data fiduciaries. So that's it. We're down with 2 sections now. Okay. Now let's take a look at the data protection principles that anybody who processes data needs to follow, because that's what the bill asks for. So the first principle is that of fair and reasonable processing. Data fiduciaries and data processors must process data in a fair and reasonable manner that protects the privacy of the data principle. Second is the principle of purpose limitation. This is something we've already covered under the Information Technology Act. It wasn't called purpose limitation specifically, but the concept remains the same. The idea is that personal data needs to be processed for very clear purposes. Those purposes need to be specified. Those purposes also need to be lawful. The third principle is that of collection limitation. Again, something that we covered under the IT Act, but not explicitly referred to as collection limitation. The concept simply being that only that data which is necessary for achieving the purpose of processing must be collected. No extra data should be collected. Lawful processing is the fourth principle, that data must only be processed on the basis of the legal grounds specified under the bill. Now we'll get to understanding what these legal grounds are in the next section. Then there's the principle of notice, and this is again similar to the IT Act, but also different in that it's much stricter under the bill. So the IT Act required anybody who was processing sensitive personal data to give notice to the people who were giving them that data of the kinds of data that were being collected, the purpose for which the data was being collected, the people with whom that data would be stored, right? Now the bill asks for that and much, much more. Data fiduciaries under the bill, and this is important, only data fiduciaries need to comply with the notice requirement and not data processors. So that's something that will be important when you are actually practically implementing this provision of the bill. So data fiduciaries have to provide data principals, that's you and I, or people whose personal data is being collected, with a notice at the time of collection of personal data. So this is a very specific time period, and it's going to be very important when the bill is operationalized, because anything here or there will be categorized as non-compliance of the bill. So companies really need to start paying attention to exactly when they give their data principals notices. So these notices need to inform principals of the purpose for collection, the identity of the data fiduciary, who am I, right? Me being the person who's collecting your data, the categories of the personal data that are collected, whether it's personal data, sensitive personal data, critical personal data, etc., etc. The basis for data processing, so the grounds on the basis of which the data is processed, the recipients of the personal data, who is the data being shared with, if at all, whether the data is going to be transferred outside the borders, that's also something that principals should be told of, the period for which that data is stored, the grievance redressal procedure, and something called a data trust score. This is a new concept. It's a lot like those trust scores that you see on electrical appliances. The idea of that score is it's a star rating. It's meant to give you a sense of how reliable a particular electronic appliance is, or how compliant it is with environmental safeguards and things like that. So a data trust score does pretty much the same thing in the personal data protection framework. It gives data principals an indication of how trustworthy a particular data fiduciary is with respect to its data processing practices. And data principals also need to be told of the existence of their rights, something that we're going to cover in detail very shortly, and the procedure for the exercise of these rights. And this is, again, significant departure from the IT Act. There were no rights to speak of for data principals under the IT Act, and that's something that the Personal Data Protection Bill very clearly provides for. The next principle that anybody who processes data should keep in mind is that of accuracy. So data fiduciaries, and again, important to note that it's only for data fiduciaries and not for data processors to follow, must take reasonable steps to ensure that the personal data that they are processing is complete, accurate, and updated. Storage limitation is another data protection principle that's important. Personal data needs to be retained only for as long as is necessary to satisfy the purpose for which it is collected. Similar to what we just covered under the IT Act as well. And accountability, that data fiduciaries are responsible for compliance with the bill. And let's now understand the grounds on the basis of which personal data can be processed under the bill. Basically, any processing activity in relation to personal data must be carried out on the basis of the grounds identified under the bill. There are 5 main grounds. The first is that of consent. The second is that of functions of the state. The third is for employment purposes. The fourth is for prompt action. And the fifth is a generic ground for reasonable purposes. And I'll deal with each of these right now. So consent, the ground for consent basically provides that under section 12 of the bill, personal data can be processed on the basis of a data principal's consent, so long as that consent is freely given and is informed through the notice that we just spoke about in the data protection principles section just before this section. And this consent must be clear and capable of being withdrawn. The data fiduciary cannot make the provision of any goods or services or their quality conditional on the data principal's consent, and sensitive personal data requires explicit consent. Okay, so simply put, in order to process data on the basis of the ground of consent, you need to seek the data principal's free informed consent. That consent should be capable of being withdrawn, and you cannot, as the data fiduciary, make the quality of your goods or services conditional on them giving that consent to you. You cannot say that if you do not give me consent, the quality of the service that I provide to you will somehow deteriorate. Okay. So when you're looking at the ground of consent, you take a look at section 12 of the Personal Data Protection Bill for reference, and you'll find that it allows for personal data to be processed so long as data principal's consent is taken. That consent must be specifically given. It needs to be informed through the notice that we just spoke about in the previous section on data protection principles. And it needs to be capable of being withdrawn, which means that the data principal should be given the option of withdrawing their consent, and the ease of such withdrawal should be comparable to the ease with which the consent is given. Now, the data, there are certain additional conditions attached to the reliance on There are certain additional conditions on the basis of which this ground may be used by data fiduciaries as well. A data fiduciary cannot make the quality of their goods or services conditional on a data principal's consent. You cannot tell your data principal that if you're providing internet access to them, that internet access the speed will be lowered if they don't give their consent to each and every data collection, data processing requirement that you have. And if the data principal withdraws their consent, the legal consequences for the effect of that withdrawal will be borne by the data principal. So this is kind of interesting and important to take note of. So that's the ground of consent for you. Ground for the functions of the state is basically, okay, no, just want to take a look at this. Now, if you recall, I'd mentioned that sensitive personal data needs to be processed by relying on even higher safeguards than personal data needs. So this plays out when you're processing sensitive personal data in terms of the grounds on the basis of which you can process sensitive personal data. So while personal data may be processed on the ground of consent, sensitive personal data can only be processed on the ground of explicit consent. Okay, so those are corresponding provisions. There are other grounds on the basis of which sensitive personal data can be processed, but if you're looking at a corresponding ground that corresponds to consent as a ground for processing of personal data, we're looking at explicit consent, and section 18 of the bill is what you should be looking at for reference. Explicit consent is basically consent plus. Okay, it's consent plus having to inform the data principal of the purposes and operations in processing that can have significant consequences for the data principal. This is not something that you needed to inform the data principal of when processing their personal data, because that just needed simple consent, and this is explicit consent. So you need to tell them of any consequences that that processing may have. To give you an example, if you are collecting certain medical data from a data principal, and medical data, if you recall, is one of the categories of sensitive personal data under the bill, you will have to factor in any consequences that this collection or processing may have for the data principal from whom you're collecting this medical data. So tomorrow, if you were to use this medical data for a clinical trial, and you are referring to that particular data principal and their medical conditions in that study, this is a consequence that the data principal should be made aware of. So that's one of the things that should be provided for in the notice when you notify the data principal and while asking for their consent, their explicit consent. You also need to be very, very specific when asking for explicit consent. So data principals need to be given the option to separately consent to the purposes for which data is being collected, the operations that are going to be carried out with respect to that sensitive personal data, and the use of the different categories of sensitive personal data that are going to be processed. So if you're collecting different categories of sensitive personal data from one data principal, you're collecting the medical data, their sexual orientation data, their religious and political beliefs, they should be given the option to separately consent to the purposes, the different purposes for which you're going to be collecting this data, and the different ways in which you're going to be using all this data. So what if you're conducting 3 separate studies on 3 separate subjects? The data principal should be able to say yes to one particular study and no to another. So that's basically explicit consent for you. The second ground on the basis of which personal data can be processed is functions of the state. So personal data can be processed so long as it's necessary for any function of the parliament or any state legislature. And it can also be processed if such processing is necessary for the exercise of any function of the state that is authorized by law, so long as that processing is necessary for giving any service or benefit to a data principal from the state, or for issuing any certificate, license or permit to the data principal by the state. So simple examples. If the state needs to give you a driver's license, it needs some of your personal information. So this personal data can be collected on the ground of functions of the state. Your consent need not be taken because that is a separate ground. Because this collection relates to a function of the state, it can be collected and processed on the basis of the ground of processing for the functions of the state. Similarly, if you are a citizen who is below poverty line and you need to get access to the public distribution food scheme, then the government needs some of your income data, some of your housing data to be able to ensure that to authenticate you as a BPL citizen. So it will need that information from you. And it need not collect your consent. The government can simply say, we need your data for carrying out a function of the state to give you a service, to give you a benefit. And so we're going to collect that data, process that data on the basis of the ground of functions of the state. Sensitive personal data can also be processed on this ground. The difference is that where for processing personal data, processing needs to be necessary for a function of the state. In the case of sensitive personal data, it must be strictly necessary. Now, what is the difference between necessary and strictly necessary is something that the courts will have to interpret. There is no actual yardstick for differentiating between these two standards. So that's something that we'll have to wait and watch to see how it shapes up. The third ground on the basis of which personal data can be processed is prompt action. So if it's necessary to respond to any medical emergency, natural disaster, any emergency situation basically that involves a threat to the life